Rise. Justices of the Appellate Division, Supreme Court, First Department. Hear, your person having business with the Appellate Division. Draw near, give your attendance, and shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. As is probably apparent to you today, Justice Gonzalez will be joining us virtually, and otherwise you have a full complement of judges on the bench today. I'm going to call the calendar. When you hear your case called, please, in addition to just identifying yourselves, let me know how much time you request for oral argument. Please keep in mind that we have your briefs and the records on appeal, and we've reviewed them, so please only ask the time that you actually need. People versus Fabian. It's 6-2 and 5. Thank you, counsel. Roman v. Zapko, 1500. Is there a respondent? Okay, 5 minutes. In the matter of Amara C., submitted. Sandy versus Trinity Center. Okay, 5-2 and 5. Thank you. Hopewell Bronx versus Montilla. I'll give you 6 and 2 for rebuttal for the appellant and 6 for the respondent. People versus Vasquez. Submitted. Ganger versus Ganger.
For the appellant, Michael Bowen. We ask for 5 minutes with 3 minutes on rebuttal time.
Okay, I'll give you 6, 2, and 6. Thank you. Zerka versus Hudson Meridian. 4, 1, and 4. Thank you, counsel. Sager versus Amchem Products.
Respondent requests 6 minutes, please.
5, 2, and 5. Thank you, counsel. Pinpoint Multi-Strategy versus Rolta. Submitted. People versus Justin Smith. Submitted. Gemini Insurance versus Golden Insurance.
Appellant requests 4 and 2.
Respondent requests 5, Your Honor.
4, 2, and 5. Thank you. People versus De Leon. Five, 1, and 2. Thank you. Noyak Medical versus OSK 9. Submitted. The first case on the calendar, please step up. People versus Bernard Fabian. You may proceed.
Thank you, Your Honor. May it please the court, Samir Degasen, pro bono counsel from Latham & Watkins for appellant Bernard Fabian. Section 222.053 of the MTRA prohibits a court in any criminal proceeding to make a determination of reasonable cause to believe a crime has been committed based solely on evidence of the odor of marijuana. This
Well, I guess the question really is, And that is what the new law says, is whether the new law is retroactive or not.
So I don't think that is the question, Your Honor, and this is a very distinct argument from the argument that this court resolved in the Pastrana case.
So we start from the premise that this court at least has held it's not retroactive. So you want to otherwise argue the common law on it.
What we're arguing, Your Honor, is not a retroactivity argument, where the retroactivity question is whether or not this whether the MTRA or this provision should have applied retroactively to the suppression hearing. Our argument is not about retroactivity. Our argument is about the fact that this proceeding, this appeal, is a proceeding that is directly governed by Section 222.053. And so that's just a straightforward interpretation of the statutory text. Doesn't involve the retroactivity question at all. We accept retroactivity has been decided, but it's a very different analysis. This is just a pure statutory interpretation question. And I think the plain text...
I don't understand. Could you explain that again, please?
Absolutely. So the statutory text here says that the MTRA prohibits a court in any criminal proceeding to make a determination of reasonable cause to believe a crime has been committed based solely on the evidence of marijuana. This is a criminal...
When did that law come into effect, counsel?
Sorry, Your Honor?
When did that law come into effect?
That law came into effect after Mr. Fabian's conviction, but it is in effect now. And so the question...
So you're saying that we as an appeals court, that we can look to the statute and we can apply the statute to the circumstances, to the facts presented here?
Exactly right, Your Honor. It's any criminal proceeding, and that... I mean,
if it's not retroactive to the suppression hearing and the determination made at the suppression hearing, why would it be retroactive for our determination? Is that because we're deciding it after the law was enacted?
Well, so it's again, we're not saying it's retroactive to any decision that's been decided in Pastrana, but it is directly governing this proceeding, because what this court is being...
Well, that's the point. If, in fact, we were to rely upon the statute, are we not therefore accepting or stating that it is, in fact, retroactive?
I don't think so, Your Honor. The statute says no determination of reasonable cause to believe a crime has been committed should be based solely on evidence of the odor of marijuana. This court has to make a determination of whether reasonable cause to believe a crime has been committed exists here based on this evidence. That's what this court is doing in reviewing these facts and reviewing this claim.
Most definitely, but in our review of the facts, we cannot consider the statute. We can only consider what the facts were as presented at the time of the suppression hearing.
I think the best way to think about this provision is basically it's actually directing the courts themselves to apply a certain framework. So it's not.
So then, do you believe that Pastrana, People versus Pastrana, which we just decided, was wrongly decided? Because couldn't the same argument that you make now have been made in that case?
It could have been made in that case, but it wasn't made in that case, Your Honor. And the only thing...
So you're saying you're making a different argument?
Correct, Your
Than
Honor.
retroactivity?
No, it's not. Again, it's sort of tricky, but it's not retroactive. So the retroactivity
Tricky
question,
or not, I'm just trying to understand it.
No,
I would understand it, honestly, if you had argued, and which is why I asked you, are you just claiming that the suppression hearing was wrongly decided based upon the common law, which might or might not be so, but I am having some difficulty making this distinction, tricky or not.
Can I just ask, are you saying that because the phrasing of any proceeding, meaning that this is a separate proceeding than the suppression hearing, and that's how we should view it?
Exactly, Your Honor. That's exactly right. So this appeal is itself a proceeding.
A separate proceeding. So where in the legislative history or anything within the statute, other than what you just stated, would allow us as an appeals court now to decide the issue based upon the statute?
So the definition of criminal proceeding is a criminal proceeding means any proceeding which A, constitutes a part of a criminal action, or B, occurs in a criminal court. This is a criminal court. This is the Appellate Division of the Supreme Court.
Well, I don't know, but go ahead. I don't know if we would be considered a criminal court, but go ahead.
Well, the way the criminal court is defined under Section 1010.
Well, I know how it's defined. You know, I'm thinking what you're arguing would mean that any time there was a new statute, right, an appellate court would have the ability to review a finding or determination based upon that new statute, if in fact that statute said in any proceeding.
If it said that, and that's a very unusual piece of language, it's the only time it appears in this statute, in any criminal proceeding is very broad, and importantly, it's different to in any criminal.
Well, there are other statutes that talk about any criminal proceeding, and I don't believe that they mean, I don't believe that it's defined the way in which you are defining it. And I also think that your argument, again, would completely do away with the concept of retroactivity in a criminal in a criminal context.
I don't think so, Your Honor, because retroactivity, you look to whether or not the statute, there's a legislative intent to make it retroactive. To, for example, the suppression hearing, it could then have all sorts of other effects.
So you do
including on
realize
cases-
that based upon your argument, what that would mean is that in every case where there was a conviction or determination on the suppression hearing, that the basis for the stop or the basis for the arrest was because of the smell of marijuana, that all of those cases would be subject to review by a higher court, the appellate division, to make a determination as to whether or not this statute is applicable or not.
Only if it's a direct appeal, but in direct appeal, then this is a proceeding. It's a criminal proceeding. This is a criminal court. And in this proceeding, you have to make a determination as to whether the evidence was based, there was reasonable suspicion. You have to sort of make that determination in order to affirm the decision below. And so this is a provision that directly governs this court. That's actually not, there are other provisions in the statute that do other sorts of directions. There's a provision that directs,
Actually, your time is up, so you'll have a chance on rebuttal to make us more attuned to what your argument actually is. Let's hear from your opponent.
Thank you, Your Honor.
Good afternoon, Your Honors. Samuel Goldfein for the people.
So I don't recall seeing this argument fleshed out the way your adversary just presented it in the papers. But what is your response to the fact that any criminal proceeding would apply to appellate review?
I think there was a citation in the brief, I don't have it off the top of my head, that the criminal proceeding, there's another statutory provision, terminated at the end of the judgment in this case. At this point, both this court, I believe the Second and the Fourth Department have all ruled that this particular section 222.05 sub 3 is not retroactive. And just as a matter of common law, because we're discussing it, doesn't make any sense to apply the exclusionary rule in a context like this. The exclusionary rule is designed to prevent the police from abusing their authority, and here, both the officers were acting well within the law as it existed at the time. Even if somehow this statute does apply to this case, which I strongly believe that it does not, there is an exception to the statute for exactly this type of conduct where the officers smell marijuana in a moving vehicle. That is still a crime, and it would allow them to search the vehicle under the context of this stop if the law existed and was in place at the time, which again, it was not. I don't know if this court has any questions about any other points about the weight of the evidence or the purported Molyneux.
Well, what about the, I'm sorry, go ahead.
Go ahead.
I was going to say, what about the issue as to the gift cards?
Yes, Your Honor.
Their admissibility.
Yeah, so the gift cards and the designer goods were not evidence of criminal activity. They were items that were in the car. The people's proffer certainly included an expert witness and also a request to bring in one of defendant's actual prior convictions to use those materials to establish intent and knowledge. The trial judge, in an exercise of discretion, sort of found that was overbroad and pared it down. And ultimately, what came in was just a factual recitation that was 5 lines of testimony that was then stricken from the record. So if there was anything improper about it at all, it was entirely harmless, especially in light of the overwhelming weight of the evidence. The defendant was observed by 2 police officers taking the wallet out of his pocket. The wallet contained 22 forged credit cards. There was no doubt that the jury was convicting on propensity. They evaluated the evidence in this case, and we can know that because the defendant here was charged with 25 counts, and they only convicted him of 22. So they weren't convicting him just because he's a credit card forger. They were convicting him because the people's evidence proved beyond any doubt that he possessed the 22 forged credit cards in his wallet. If there are no further questions, I ask that you affirm and rest on my brief.
Thank you.
Thank you.
Counsel, rebuttal.
Thank you, Your Honor. So the argument I think we just heard requires reading the word criminal proceeding and changing it to the word criminal action, because the provision that he just said is relevant here is the provision that defines criminal proceeding, which is CPL 1.02 brackets 18, and that says criminal proceeding means any proceeding which A, constitutes a part of a criminal action, or B, occurs in a criminal court and is related to a prospective, pending, or completed criminal action. So criminal proceeding is broader than criminal action, and the government's theory in this case is this language only applies up until there's a sentence. That's a criminal action, not a criminal proceeding. So that really involves changing the language the legislature used in the MTRA. He also quickly mentioned the exception. The exception is not in play in this case. That's an exception for intoxication. There was no evidence, it's never been argued any time down the line that Mr. Fabian was intoxicated. And finally, on this question of the gift cards, Your Honor, that no one has disputed at any point that these gift cards were not used for any criminal purpose, that the designer goods were not criminal. They even tried to investigate it and found no link. There was just things in Mr. Fabian's boot, yet it was presented to the jury 5 times that Mr. Fabian had these things, clearly implying.
Well, there was
Go ahead.
Why wouldn't, even if you're correct, why wouldn't it be harmless error?
Well, I think that it would only be harmless ever if there's overwhelming evidence of guilt and
22 credit cards, I think, fall out, or a bunch of credit cards fall out of the wallet. Isn't that evidence of guilt?
I don't think so, Your Honor, because the question is whether or not he possessed the credit cards. The jury was never instructed on constructive possession, so it's did he exercise dominion and control.
I don't understand. Why would that not constitute possession?
Because no one ever witnessed him possessing the cards. They were on the console between him and Ms. Good.
Was that even argued? Was it even argued that there was no proof of possession?
That was the central issue that was presented to the jury. In fact, the jury even asked the trial judge for a sort of clarification, which was, is it enough for these cards just to be in the car, or does he have to have actually possessed them? And the judge didn't give that clarification. So
But there was more than that. It wasn't just that they were in the car on the console. The police officer testified that the defendant took out his wallet and put the wallet on the console, and that the cards fell out of the wallet that he possessed that was on the console. Wasn't that the testimony?
Right, the theory, but that of course is totally consistent with Ms. Good putting the cards in the wallet.
But the jury didn't believe it. They believed the police officer's testimony in terms of that the cards were in a wallet that was possessed by your client. So I'm not sure where that gets you. But I think we understand your argument.
Great, and the other thing I'd say is that even if that was the case, Your Honor, it's not overwhelming evidence of guilt, and that's what would require for the
Circumstantial
harmlessness.
evidence would counts. Okay.
Fair.
All right, thank you.
Thank you, Your Honor.
Mr. Bosworth, I know you're here pro bono, and I'd like to thank you for your service, and please extend our thanks to your law firm as well. Thank you both.
Thank you very much, Your Honor.
Okay, step up on Roman versus Zapko.
Good afternoon. David Tolchin from Droslowitz and Jaros for the plaintiff appellant. Affirming a question of fact here would inject contributory negligence into a 240 case, and this court should not start down that road. The court...
Contributory negligence?
Comparative negligence of the plaintiff, and that has no place in a 240 claim. The court should find for summary judgment in plaintiff's favor. Here, there is no sole proximate cause issue at all here. The plaintiff did not choose not to use an available safety device.
Was there an available safety device?
No.
Okay.
In fact, he asked his supervisor for a proper safety device, a manual forklift, and the supervisor said, no, you're strong enough, you can deal with it, just use your own strength, you're strong enough. And he and his foreman, Luis, and his coworker, Umberto, were all trying to take off this enormous, massive 400-pound...
Yeah, we're familiar with the facts. What your client had was a baker's scaffold.
No, he didn't. There was a
Didn't
baker-
have that either.
There was a baker scaffold in Maspeth, Queens. What the plaintiff had was his own two hands and those of his two coworkers in Times Square, Manhattan.
Correct, but here's the point I was getting to. You had an expert in this case, did you not?
Yes.
And your expert said even if they had a Baker's scaffold, that is not an appropriate safety device.
Exactly.
For the work that was meant to be done at this work site, correct?
That's correct.
And was there anything rebutting that in the record? Anything raising any issue of fact about that?
Not at all. All we have is the plaintiff's boss, ultimate owner of the company, who said, use an available scaffold. But when he got there, there was no available scaffold. There was no scaffold at all. He didn't have one. Mr. Greco, the boss, didn't tell anyone to transport it to Midtown Manhattan. His foreman didn't arrange to have it there. The building owner didn't have it there. And these three workers did not have any device, and they were trying to take down a quarter-ton, 6-foot-tall marble form. You can't do that with just your hands. They had no choice but to rest it for a second on the pipes, and then they fell and crushed the plaintiff. If there are no further questions, I would rest on my brief.
Any questions, colleagues? Thank you. Thank you. Sandy versus Trinity Center, please step up. You may proceed.
Thank you. May it please the court. I am Richard Ashnault from the law offices of Kevin P. Westerman, here on behalf of third-party defendant Appellant AC Electric of New York, Inc. What we have in this case, Your Honors, is a kind of an intersection of Labor Law 241-6, Industrial Code 23-1.7E2, and General Obligations Law 5-322.1. One of the things that is very important here is that the general contractor and or their subcontractor was responsible for removal of the debris, which has been found by this court already to have been a cause of the accident.
Isn't that just a straight pass-through liability?
I'm sorry?
Isn't that straight pass-through liability under 241-6? So isn't there a way that this indemnification clause may come into effect if it's found at trial that the GC was not negligent, for example?
Well, the argument here is, though, that this court's finding that there was a violation of 241.
But that was my first statement to you. Wasn't that just a straight pass-through? It's a statutory liability situation.
Well, it's a statutory liability that makes the GC liable for someone else's negligence.
Correct, and we don't know who is negligent here. So doesn't there have to be a finding at trial with respect to negligence? And then the question arises whether or not the indemnification clause would violate public policy or not.
Well, because of the 241-6 finding already, it's undisputed that it was either the general contractor or their subcontractor that was responsible for the removal of the debris.
Well, if the GC wasn't responsible, for example, and
I'm sorry?
if there was no negligence on part of the GC, then under those circumstances, couldn't the indemnification provision at least apply to the GC?
Well, the indemnification provision would then still be in violation of 322.1.
Well, if the GC is not negligent, how does that violate public policy?
Because 322.1, by its very terms, prohibits the indemnification of the negligence of the GC or its agents. And if there was an agent that was responsible for the removal of that debris, which there had to be, it was according to the testimony of the GC's witness, it was their subcontractor, we would not have to, AC Electric would not have to indemnify either the GC or its agent for the negligence of the GC or other agent.
Okay.
All right? If there are no further questions, I will rest on my brief.
Thank you.
Good afternoon. My name is Evie Kazansky, and I represent all the defendants in this
Can
action.
you respond to that argument that the indemnification provision, based on our finding, would violate public policy? Because it's either the GC or its agent would be responsible for the underlying condition there.
So I think the central issue is the fact that the original decision that we're talking about, which I'll call Sunday 1, did not find at this time that Tricon, who is the general contractor, had any active negligence. Therefore, at this time, there's only a violation, and there's no decision on who or what was the proximate cause of this accident. Therefore, as a long line of decisions in the first department, even if a contract is violative of the general obligations law in a construction context, if there's no active negligence, and I think that's the issue that the third-party defendants are missing, is that they're reading the first decision to find active negligence. It's clear from the first decision that Joseph A. Bank, who is the tenant, who wanted the work being done, and the owner, Trinity, were found not to be negligent. And that was in a subsequent decision by the lower court that has not been appealed. So the two of them are not negligent, and even if the decision...
Well, what about the GC?
The GC has not been found negligent yet, and the decision about his talking about the garbage and the things are actually went to the common law and the 200, which this court specifically said there are questions of fact about. Whether or not we knew about the garbage, whether or not we had the garbage cleaned when we were there, whether or not the plaintiff complained about it.
That's not quite accurate, right? Because there was debris on the ground, and there was a box which plaintiff fell over. So arguably, it could be as a violation of the industrial code regulation. No.
I think we're using the word violation, excuse me, incorrectly. There was clearly debris, and that would cover 1.7E2. The secondary part of 241.6 is the proximate cause issue, and that requires a finding of actual negligence. Otherwise, as you've suggested, Tricon would be able to passively pass it through. So there's no active negligence yet or ever on Tricon. So at this time, the enforceability of the contractual indemnification clause, irrespective of the violative nature, which we also in my brief say it's not, but you're focusing right now on the secondary issue, is still, as the lower court suggested and properly suggested, is still an open issue. So a violation of 241.6 is not necessarily proof of the proximate cause by a party, as you suggested. Tricon could pass it through if they're found not actively negligent. At this time, the first decision of this court said there are issues of fact as to the common law and labor law 200, which is active negligence upon Tricon.
So your argument is basically it's premature to figure out whether or not this provision is enforceable until we have an adjudication or some indication of who's been negligent here. Is that correct?
I could have saved a lot of paper saying it that way.
So, but here, is there also a question about whether Tricon, just because it's a subcontractor, whether it qualifies as an agent under the general obligations law? Or is that a conceded point?
No, Tricon was the general contractor. There was never an issue. I'm not sure why the issue of subcontractors was brought up. We were the general contractor. We had the contract with Joseph A. Bank, who was the tenant in the space, to Trinity. So it was the three of them.
That's not the issue. The real issue that's really left that needs to be figured out before we can decide the indemnification, if any, is whether Tricon was negligent.
Yes, and also which is not an issue right now, I can see that whether or not the contract, if you find it enforceable, because we say, even without the savings clause, there have been cases by this court that have still found it enforceable. It's only triggered by certain things that AC Electric does, and one of them is including the negligence of its own employees. And that hasn't been decided yet either, and that was clear from the first decision also. Thank you.
Okay, thank you. Rebuttal?
Just returning to that agency question for a moment, using the language of Rizzuto, 241.
I think your adversary conceded that issue to you, right?
Conceded the issue that
That Tricon is an agent within the meaning of the general obligations law. So if Tricon is negligent, then we can resolve the issue of whether this is an enforceable indemnification provision or not.
Well, my argument here is that their subcontractor that was responsible for debris removal is actually an agent under the general obligations law. So either way, it's either them or it's their subcontractor.
But I don't understand that. There was an electric box on the ground as well, correct?
I couldn't.
There was an electric box on the ground, right?
The electric box on the ground was designed to stay. So that's
There was an electric box on the ground that was put in by you folks?
No,
It wasn't
that
put
was
in by
not
you
part of
folks?
our work. There was a removal of the floor down to the slab, and the existing boxes were to remain, and they stuck up a certain amount over the level of the slab. So those were to remain by design. That had nothing to do with the work.
So it's your position, in effect, then, it's either the GC or its agent that's responsible for debris removal. But can we make that finding as a matter of law? Doesn't that require a trial?
I don't believe it does, Your Honor, because of the very nature of 241-6. It requires the GC to answer for someone else's negligence. So there generally has been a finding, if they have violated 241-6, that it's either the GC or it is their agent, that it was negligent for whom they are answering.
Okay, thank you. Thank you both.
Thank you.
Joe Paul Bronx against Montilla.
Good afternoon.
Proceed.
Angela C. Belizzi, attorney for the appellant, Joe Powell Bronx, DBA Workman Circle Multi-Care Center. May it please the court, appellant maintains that it had met its burden of proof on its motion for summary judgment as against the respondent, Milagros Montillo, when it, on its causes of action for medical necessaries and tortious interference with the contract.
Can I ask you a question? Assume for a minute, I want to go to the issue of sanctions. You know, here for a moment, obviously, if we agree with you that you met your burden of proof and that this was wrongly decided on the merits, then the issue of sanctions falls away. But I'm going to ask you the question, assuming for a minute that we agree with the trial court that you didn't meet your burden on summary judgment, is this otherwise a sanctionable case? Should sanctions have been awarded against you?
We would maintain, appellant would maintain that the causes of action that were pled are based on longstanding existing common law theories of recovery, under which there was certainly no frivolous conduct, and there was certainly no, that the plaintiff at a minimum met its burden of proof to sustain the defendant's motion to dismiss. There was, if the court were to find that the appellant did not meet its burden of proof on summary judgment, at a minimum, the court was premature in its granting of the motion to dismiss. giving every benefit of the doubt to the appellant as pled pursuant to the requirement of this 3211A7 on the CPLR.
On that issue, as to the necessaries, did the complaint, or how did the complaint properly allege that she was, had the ability to satisfy the debt, or that she was, the primary debtor was unable to satisfy the debt? Was that inside the complaint?
Well, there is a presumption, our position is that the credit concept, you're saying that it wasn't that the resident or the respondent had the ability to pay, but it was, the court interpreted this, the concept of credit means that the respondent had relied on her promise to, the facility, I should say, relied
But how did
on
you
the
show that?
respondent's promise.
How did you show, well, was she, for example, asked about her finances? Is there anything, she didn't sign the form, so how could you show that the care was provided based on her credit?
Well, there's a presumption of that the services were, case law, Our Lady of Lourdes Memorial Hospital versus Frey, there's a presumption in the creditor's favor that any necessaries furnished were presumed to be on the credit of the spouse. Here, the credit was not the...
That's true, but the presumption doesn't go so far as to say that otherwise that the spouse had the wherewithal to otherwise pay the debt here.
Here...
You know, Lourdes breaks it up into those two aspects, and what I understood from the court below is I said where your case failed is that you don't show that she had the wherewithal to otherwise pay the bills of the nursing home herself, right?
But the documentation to establish whether or not she had the ability, the financial wherewithal to pay was exclusively within the respondent's control.
Yeah, but wasn't
the request,
this done on the, I mean, as I understood what was going on here, and I can't say it's a complete record, but it looked like what was going to happen here is that the husband was taken in, he needed the services, and that there was going to be a Medicaid application be prepared with the assistance of the nursing home, which is commonly done, so that the nursing home could get paid for the services. Isn't there just underlying the idea of a Medicaid application is that neither the husband nor his spouse could otherwise pay directly for the services that the nursing home was providing. They wouldn't have qualified financially for Medicare if they had the wherewithal to personally pay.
But the qualification, they had to document their eligibility, and the Medicaid rules required that when you apply as a married applicant, the documentation of the spouse, whether or not they have the financial wherewithal, must be presented so that Medicaid, the New York City Human Resources Administration, can review and make an assessment, determine whether there are any improper transfers.
Milagros is claiming that you never asked her for the information.
We submitted affidavits.
Well, that goes to my
otherwise.
colleague's question. He asked, how did you prove that you did, in fact, request this information?
We submitted affidavits from the business office that had communications with the wife regarding the documentation that was needed. An application had, in fact, been submitted to the Department of Social Services.
So didn't she tell you, at some point in time, didn't she reply that the information that you requested from her bank required, for whatever reason, the bank was requesting a fee of over $500, and she did not have the means to pay the bank the $500 for those records?
It's the appellant's position that they were unaware that the bank had ever requested any fee. They could have paid the fee.
So your position is that she never, I thought she stated this, I don't recall whether it was an affidavit or what have you, but I thought she stated that this had been made known to the appellant, to the nursing home.
No, our brief actually stated that it was a self-serving affidavit that she indicated, you know, after the appeal rights to the Medicaid denial had already lapsed, that the bank had asked her for a fee. Had she told the facility that there was a fee, the facility could have either paid the fee themselves to get the documentation, could have submitted the request to the bank, to the Department of Social Service, to perhaps trigger the department's review effort to conduct a collateral investigation. There was no discussion or cooperative effort with the respondent to the facility so that they could work cooperatively to document eligibility and for Medicaid, and that was the issue, and that's the reason for the denial. Her documentation is stated as missing on the Medicaid denial notice. It was the spousal documentation which is required under the regs.
So that sounds more like a breach of contract you would have against the wife, correct?
Well, the claim,
Not really tortious interference.
but there is no express contract between the facility and the wife, hence the tortious interference.
Well, there's an implied contract that she'll cooperate, no?
There is an implied contract. There was the promise, based on the conversation that they had, that she would agree and provide her documentation.
But you didn't assert that in this case, correct?
I'm sorry?
You didn't assert a breach of an implied contract in this case, correct?
We asserted the tortious interference claim. She was aware of the implied contract and the express contract that existed between the facility and her husband.
You know, just getting back to the sanctions decision, you know, which at least for me, there's two separate considerations here.
Yes.
In the sanctions decision, the judge in fact noted that you might have had breach of an implied contract claim against the wife here because she didn't cooperate as was necessary to otherwise apply for Medicaid benefits. Right?
Yes.
Okay, let's hear from your adversary.
Okay, all right.
Go ahead.
Good afternoon, Your Honors, and may it please the Court. My name is Sarah Rosenthal with the New York Legal Assistance Group, and I represent Defendant Appellee Milagros Mantilla.
Counsel,
Go ahead.
I just have a question. In terms of the Lourdes analysis, why isn't this issue on the issue of necessary something that should move forward towards a jury trial?
Your Honors, appellant failed to even plead the four elements of the doctrine of necessaries theory. As Your Honors pointed out, there is not a single mention in the pleadings regarding Ms. Mantilla's ability to pay. Appellant relies on Our Lady of Lourdes, but that case itself demonstrates that there must be an ability to pay, and Our Lady of Lourdes similarly states that liability is not automatic, and in fact, summary judgment was denied in Our Lady of Lourdes because the medical provider looked first to the patient's insurance, which precluded a finding of liability on behalf of the spouse.
But the suggestion seems to be that there could not be any determination on appellant's part as to an inability to pay because that was never communicated to them by your client.
Your Honor, it is appellant's burden to plead their causes of action correctly. They did not do so. The trial court was correct in dismissing the cause of action because they did not even assert there was an inability to pay. And I would respectfully submit that the burden would be on the nursing home to establish that there was an ability to pay. And the reliance on credit is belied by the fact that appellant themselves in their own pleadings admits that they expected the Medicaid program to pay. And I would respectfully submit that the appellant is conflating the reliance on credit with Ms. Mantilla's cooperation, which they allege is the basis for their tortious interference with contract.
This was already discussed. In order for Medicaid to pay, she, as the spouse, had to provide financial information for her husband, the patient, as well as for herself. Did she not?
That is correct, Your Honors. But first of all, as is elaborated upon in the papers, there are other ways to ascertain eligibility for Medicaid, such as a spousal refusal, such as the Department.
In order to get a spousal refusal, they'd have to get it from her.
Yes, Your Honor, but as
So one way or another, she's got to be a participant in that application in order for him to otherwise qualify for Medicaid.
And as Ms. Montilla's affidavit establishes, which is the only affidavit from anyone with personal knowledge, and I do want to point out to your honors that my esteemed colleagues misrepresented the content of the Rozier affidavit. There is nothing in the Rozier affidavit that alleges any communication between the nursing facility and Ms. Montilla. Ms. Montilla did, in fact, try to cooperate. She did her best, and there is nothing in appellant's record that indicates an effort to communicate with Ms. Montilla, but Ms. Montilla herself, in her sworn statement, establishes she did what was asked of her. She communicated with the appellant.
Well, I'm going to move you forward to the sanctions part.
Yes, Your Honor.
You would agree with the proposition that just because a party loses or their complaint is dismissed, even on the pleadings, that's not a basis for finding litigation frivolous to impose sanctions, is it?
Your Honor, generally,
It's a general proposition.
But in general, no, but in this instance,
Okay, we're good there. Now, what distinguishes this situation from the run-of-the-mill situation where somebody pleads a cause of action and they just don't plead enough?
So, Your Honor, thank you for allowing me to clarify, but in this case, it's because the appellant failed to undertake any sort of analysis or factual investigation to even allow them to even state the legal standard. The failure to state the legal standard, and as both the Honorable Judge Crane and the Honorable Lucy Billings found, there was no basis upon which Ms. Montilla was even aware of why she could possibly be held liable for a debt that was not hers. The pleadings were so deficient that an award of sanctions in finding this action frivolous was merited in this case. That there was
it's the bad lawyering that would otherwise justify the sanctions in this case? Is that it?
Well, it's the failure to even plead that led to an action that was dismissed outright that caused Ms. Montilla to unnecessarily.
So in other words, every time a case is dismissed, that event is sanctionable?
Your Honor, there is a basic assumption that in a pleading that at least all of the elements of a cause of action will be pled.
But again, that's the question. Why is this different from your other cases where there's quote-unquote bad lawyering, where an attorney fails to properly plead?
Because, Your Honor, these papers, the pleadings of the appellant, were so deficient that it could not even be established how they were attempting to hold Ms. Montilla liable, and that both the Judge Crane and Judge Billings found was insufficient to even put Ms. Montilla on notice to prepare her defense, and that rose to the level not of sanction. And I will note
that would justify dismissal. Maybe I'm not sure why that is necessary. You know, where you're drawing the line that makes it frivolous.
And well,
some people draw better pleadings than others. Some people, I mean, we get pleadings that don't survive a motion to dismiss all the time.
Yes, Your Honors, and just to respond briefly, I realize my time is up.
Okay.
That Judge Billings did not award sanctions. She did award fees for the time it took Ms. Montilla, especially after the appellant was.
What's the difference? Who says you can award fees? You can award costs. How can you award fees? Since when? What happened to the American rule?
Well, Your Honor, it is within 22 NYCRR 130-1.1.
For frivolous conduct.
For frivolous conduct, and I would respectfully submit
so
this
that's
was.
sanctions. You could call it Irving. You could call it Flowers. It's sanctions.
I understand, Your Honor.
Okay.
Thank you,
All
Your
right,
Honor.
good.
I appreciate Your Honor's time. I rest on my brief
Thank
and
you.
ask you to affirm.
Every time you do
Thank you.
you just kill me with everything.
Okay. We're good. Rebuttal?
Your Honor, Your Honors, I would maintain that the pleadings that were submitted set forth valid and claims against the respondent under medical necessaries and tortious interference. Any alleged.
Your adversary says you failed to plead all the elements. Isn't that correct?
On her motion to dismiss, the lower court should have given the plaintiff, the appellant, every benefit of the doubt in reviewing it.
Did you plead all the elements of the cause of action?
Yes, it's our position that we did. And certainly any pleading that validly stated claims cannot sort a basis for sanctions. I agree. My interpretation, you can call it what you want. It was worded as cost, There was no supporting affidavit, which generally supports an application for costs. And there was no basis here for an imposition of cost sanctions, whatever the
Well,
lower
costs are different. Costs are statutory, right? You know, it's the $60 or whatever you paid to file a motion.
Right, but this was $2,500 and it wasn't
It
grounded
seemed
in
like
any-
it was really compensation for the other side's legal fees, right, in some part.
And there was no supporting documentation to substantiate what those fees or costs were to support the award. Okay?
Okay, all right, thank you. Thank you both.
Thank you, Your Honor.
Ganger versus Ganger.
If the court please.
You may proceed.
My name is Michael Bowen. I'm here on behalf of the appellant, and this is an appeal from a refusal or a denial.
Isn't this deja vu all over again?
It is for me, Your Honor. We've
For me
been on-
too. Well, maybe not on this one, but at least reading through the record, it seems like we've litigated this issue to death, and we're back again on the same issue.
Well, this case has been before this court multiple times on appeal. That is certainly true, and it's been handled in a way that different causes of action were tried separately from other causes of action.
So how is the fraud you're alleging different from what we decided in the prior appeal?
Well, the fraud is, first of all, against a separate defendant. It's not
What-
against...
How is it different? The damages are the same, no?
The damages are different because it involves different time periods, different wrongful conduct, and then different measure of damages. The damages below on the breach of fiduciary duty against a co-defendant, namely Sagi Ganger, who's the brother who took all of the family property away from his sister, the appellant, who is now bankrupt. But that breach of fiduciary duty, the measure of those damages was a sham UCC1 auction sale that he held in early 2009. And the court below found that him conducting that sale in the way that he did it, because he
Well,
was the...
yeah, right. We don't need to go through ancient history because we are familiar with it. So you got a Orly got a determination of liability against her brother, and it was sent for a damages trial, correct?
Correct, Judge.
And how were the damages calculated that would yield something different here for the fraud that is claimed against the mother, who was the trustee of the Orly Trust, in connection with the sale of the note, essentially?
Yes.
Tell me, what's the difference? Where's the difference?
Well, the difference is that the breach of fiduciary duty damages was limited to the UCC sale. So the question was, what would a reasonable buyer pay, knowing about all the litigation going on in the family and knowing about the financial condition of that company, TPR, as of that moment in time when the sham auction began? The fraud is alleged...
I thought it was right before.
Right, the ex ante...
Because the idea was that the auction didn't yield the fair market value. So the proxy for value was the value of the note prior to the auction, right?
But just prior to, in August of 2008, when the sham auction proceeding began. But the fraud began 4 years before that, and there were other...
Is that allegation, I know you make that argument, but is that allegation in the Second Amended complaint?
Yes, it is, Your Honor. It's after the decision by Justice Feinman, which upheld the fraud claim. And in that Second Amendment complaint, which came after that decision, there's specific allegations about wrongful conduct by Orly...
Well, it says plaintiff reserves her right to bring a shareholder derivative action on behalf of D&K related to Sagi and Dahlia's dissipation of TPR's assets, but she has yet to do so.
But that's a separate entity that has a separate standing right in terms of recovering damages. Orly, it's not inconsistent or incompatible with Orly Ganger's right, because the property ultimately was hers. She was the ultimate beneficiary. So the wrongful act by Dahlia Ganger, by the defendant in this claim, this fraud claim, began in 2004, and it involved omissions and fraudulent statements in which she was giving control over the family company and family assets to the brother, Sagi. And the purpose of that was that for Sagi to dissipate those assets so that by the time the TPR sale, the auction, the sham auction...
What was there besides the TPR sale?
Well, there
What
were
other
other
assets?
assets held by TPR, Judge. There was the TRI shares, which has to be distinguished from TPR, but those shares were very valuable, worth tens of millions, if not hundreds of millions of dollars. That asset is specifically mentioned in the complaint. There's a mention about a $27 million asset that Segui got from selling certain parts of the TRI shares. There were concerns that they were putting.
Well, wasn't that part of the claim of the breach of fiduciary duty?
No, it was not. TRI had nothing to do with the breach of fiduciary duty, Your Honor. So the assets that went in and out of the TPR ledger, the balance sheet, was never adjudicated below. There's nothing in the record below to say that the measure of damages for the fraud claim against this defendant is somehow the same or identical to the measure of damages for a different tort.
So there was a 6-day trial, right?
There was a
There was a
damages request.
6-day trial, right? And the determination as to damages was made, and the JHO, I believe, right, stated that the plaintiff had sustained no damages.
Yes.
So your position is, although during that 6-day trial, all the evidence which was presented concerning the breach of fiduciary duty, had nothing to do with Dahlia in terms of damages as to her?
That's correct, Judge. Even though we tried to put on, she was a witness in that trial, and we tried to put on evidence of her misconduct. We even made a motion to be allowed to conform the pleadings to the proof to show that the breach of fiduciary duty started long before the sham UCC sale, and it was denied. So Justice Gammerman, who was the retired justice sitting as a JHO, he actually suggested that we do that because there was much more evidence than what the court was limiting us to for the breach of fiduciary duty as to Segui. It was really just limited to that sale at that moment in time in August of 2008. But everything that happened up to August of 2008 informs the fraud and the measure of damages of the fraud. And Orley had direct expenses, out-of-pocket losses as a consequence of that fraud, which began as far back as 2004. Now, that's in the complaint, in the Second Amended complaint. When this dismissal happened, nobody had made an argument that the damages were somehow issued.
But I thought that there was a determination and there was evidence as to Sagi's dissipation of TPR's assets starting in 2004.
No, there was not, Judge. The rationale...
There was not?
Not from 2004. The judge said that in 2007, there was some proof that there were about $12 million worth of assets in TPR. But at the same time, there were liabilities that outstripped that. There were like $16 million in liabilities. And because of that, the judge said that's not sufficient to allege damages on the basis of the breach of fiduciary duty. But the question is, where did those liabilities come from? And what were they? And who was responsible for putting those on? And that goes to the fraud that was never adjudicated. There's nothing in the record that goes to those liabilities or even to that analysis because it was really just focused on the balance sheet of that company right before the sham auction began.
Okay, let's hear from your adversary.
Thank you.
Thank you.
Good afternoon, Your Honors. Carmen Saparik for Respondent Dahlia Ganger. As you well know, this case has been before this court many times before. It's been before the surrogates court. It's been in the federal court. It's been before a court in Delaware. And what Judge Jaffe did here, she finally brought it to an end. And she brought it to an end and marked it disposed as early as March 25th.
Is counsel correct that the Second Amendment complaint does allege dissipation of TPR assets going back as far as 2004? And were those, if the answer to that is yes, were those issues adjudicated before JHO Gammerman?
The complaint alleges misconduct going back to early to 2004.
With respect to
with respect to
dissipation
Dahlia,
of
with
TPR.
respect to my client Dahlia, yes. However, the way this was tried and the way it's been tried for the last 12 years, et cetera, it seems that Orley's, what she was seeking was a derivative claim of damage to her trust. And the measure of damages is out-of-pocket expenses. The measure of damages is indemnity. And that was proven at the trial before Judge Gammerman. Judge Jaffe confirmed the referee's report. She denied the motion to reject. She entered a judgment.
So are the damage, I guess what I'm trying to get at, are the damages the same? Are the damages that
We
were
maintain the
adjudicated
damages.
before before J.H. O'Gammerman the same as what was, as what counsel is seeking now?
Yes, we maintain the damages are identical, that's the only quantifiable damage that could be proven at the time, that it was a scheme that Dahlia, the mother, and her son, Sagi, concocted to fleece Orly of her assets and the monies in her trust. And this is the way this was tried the entire 12 years. And I believe that now they're bringing up from 2004 through 2008, but there's never been anything. They had an opportunity at the trial. They could have cross-examined Dahlia. They could have brought a summary judgment motion.
But your
Could have had
adversary seemed
discovery.
well, it seemed, he just stated that he was precluded. He was precluded from arguing as to anything from 2004 as to Dahlia during the
Judge
6-day
Gammerman's
trial. Yeah.
in the hearing.
Yeah.
Well, Judge Jaffe defined what had to be tried, and yes, indeed, there was a motion to conform the pleadings to the proof. It went back to Judge Jaffe, and she did expand it somewhat. So that is true. I don't quarrel with that.
So were the issues with respect to the dissipation of the TPR assets, was that ever adjudicated?
No, that has never been adjudicated. And as you mentioned earlier, Judge Weber, you mentioned the footnote 6 in the complaint where Orly reserved her right to bring a derivative action for dissipation of assets and mismanagement of the funds, et cetera. She never brought that action in the 12 years that this has been pending. So what Judge Jaffe did here, we feel, she believed that there was no injury, that there may very well have been a fraud, but without damages and without injury, there's no cause of action. So she disposed of it. She disposed of it 3 times or 4 times, and we're asking you to affirm her decision. Oh, I see okay. I'd like to mention the issue of standing. We believe that the trustee has no standing here because this...
Should we defer that decision? Is bankruptcy court making a decision on that? And would it be better to defer that so we don't have inconsistent decisions, for example?
Well, it could be, but this court in recent cases has discussed the whole issue of derivative claims versus direct claims. And this is a derivative claim, and she sued in a derivative capacity from her first complaint that she filed back in 2009. She sued in a derivative capacity. So according to the bankruptcy law, that doesn't belong in the bankruptcy estate. It doesn't pass the bankruptcy estate, and that's our position. So they also talk about procedural irregularities. The procedural irregularities, if they existed, were brought on by them. They had brought an order to show cause, made returnable October 16th. We had until October 11th to put in papers in opposition. On October 3rd, we received a letter asking the judge to advance the return date to either rule sua sponte or to, because they claim that this claim is to be removed to the bankruptcy court, and they had a deadline. So I received an email from the judge's law clerk at 6:13 on October 3rd, asking me to put in my opposition by 10 a.m. October 4th, which we did, and that's the email, and that was all the opposition that we were able to put in at the time. I see my red light is on. Thank you, Your Honors.
Thank you.
Thank you.
Rebuttal.
Yes, Your Honors. Justice Singh, your question about the fact that the dissipation of the assets were pleaded starting back in 2004, If you look at Justice Feynman's decision, which was the decision upholding the fraud claim against this defendant, on page 24 of the record, he writes, quote, "There are also the transactions over the years that apparently have given Sagi Ganger and Dahlia Ganger potential control over family assets in a way that has harmed plaintiff's share." That's exactly the fraud claim against Dahlia Ganger that's in the complaint, in the Second Amendment complaint, which followed this decision by Justice Feynman, and it had been pleaded the first time
Can you be
around
a
as
little
well.
bit more concrete or with an indication in the record as to what additional damages are you claiming for what specifically?
Well,
I'm having trouble wrapping my head around it.
The damages relate to conduct in Dahlia Ganger giving control surreptitiously.
I know you keep saying that, but give me an idea. So what asset did it affect? How did it affect? I mean, what are we calculating damages on?
Well, there were
other than the note, and just give me a more concrete explanation about what the fraud cause of action is seeking in damages that is different than the breach of fiduciary duty. Go ahead.
It goes to the assets that were in the estate that was supposed to be split equally between the two.
Which were what?
Which in 2004 were the TPR assets that were in the company in 2004 and included tens of millions, if not hundreds of millions of dollars worth of TRI shares. Some of that money was eventually sold in this period preceding the sham auction in 2009, and that was a $27 million of cash that our position is, and it's cited in the complaint. I'm looking at record 76 to 77, record 98, the paragraphs there, which talk about these assets in particular that Dahlia Ganger, through her fraud, was allowing to be dissipated from the company long before the sham auction. And it's in the complaint. And the fact of the matter is that nobody has provided an analysis at any point in time, either the court below or our adversary, that made some kind of motion and presented some kind of evidence that showed that there was an identity of issues. There was no argument at all. There's no argument in the order being appealed. There's no analysis. There's no analysis by our adversary in what they submitted to the judge when we were trying to vacate the sua sponte dismissal. So there's just never been any analysis outside of the complaint. And the complaint itself lists conduct starting in 2004 and lists assets that existed back then. And those are the assets that we are saying that Dahlia's fraud ultimately and her wrongful conduct, which began, again, 4 years before the sham auction.
So you're saying the $27 million was dissipated?
I'm saying that's a piece of it, Your Honor.
And
it's not even all
with
of it.
respect to that piece, so what was the loss by the plaintiff in that? Half of that?
Well, yes, 50% of that belonged to her ultimately through her trust, because each of the children had their own trust, and then they were the ultimate beneficiaries.
$13, $14 million, you say, at the very least.
At the very least. And we say there's more assets in TPR than that, and we've made arguments about that. That's, again, in the complaint. There's a specific reference to $11 to $12 million in other assets that existed in the complaint. Now,
None of this was discussed during the trial.
Well, that's correct. There was never any evidence about the assets that existed in TPR prior to August 31, 2008.
Wait, no, my question is, there was no discussion or no evidence presented as to the $27 million that you're just referring to.
There were references to those figures, Your Honor, in the inquest before.
Were you seeking the $27 million against the brother, Sagai, at that? In your claims, in her claims against him?
In the damages inquest, we sought to expand the relevant period of time to look at what the damages were, to look at the total dissipation, which began long before August of 2008. We specifically asked for permission to do that, and we were told no by the judge below. Because Justice Gammerman, J.H.O. Gammerman, recommended it. We made the motion to Justice Jaffe. Justice Jaffe said no. So we were limited only to the value of the TPR shares as they existed when the auction started on August 31, 2008.
But in the complaint, do you allege, and I'm gonna go back and look at the complaint again. Do you allege that the dissipation of assets was also prior to the auction sale, that the dissipation of TPR assets was also a breach of fiduciary duty?
No, well, that's a good question, Judge. Arguably, that was not set.
Thanks.
Well, arguably,
right.
that was not set forth
Yeah.
in the fiduciary duty breach as to Sagi, but it is set forth in the fraud action as against Dahlia.
That's what, I'm going to look at that. The other thing is, what is your response to your adversary's claim that you, as the trustee in bankruptcy, and that's who you're representing, and it's Orly's personal bankruptcy, that you don't have standing to assert a claim that really belongs to the trust?
Well, that's a mixed question of fact and law, Your Honor, and the fact of the matter is there's no record on that either. And conceptually, logically, both Orly in her personal capacity has damages from the fraud that was committed, and arguably so does the Orly Ganger Trust, not the bankruptcy trust, but the trust, the family trust below. The problem with that is that the beneficiary can still be awarded personal damages when you're dealing with a corrupt trustee. And for a large portion of the facts that are alleged in the complaint, Dahlia Ganger became the trustee of the Orly Trust. So to say that the Orly Trust gets damages at the expense of Orly personally doesn't make any sense. And we cited law on that. There's a matter of Rothko and other cases like that, which are in the reply brief, pages 20 to 24. So even if the concept is that the Orly Ganger Trust itself as an entity has standing to make these claims, that doesn't preclude Orly personally making those claims herself, because she's ultimately entitled to those damages, or at least some of them, because she was personally damaged and had out-of-pocket financial expenses in trying to uncover the fraud and pursue it. And that's why, because anything she's entitled to personally is part of the bankruptcy estate. And that's why the bankruptcy estate is pursuing this appeal.
Okay.
Thank you very much.
Thank you both. Zerker versus Hudson Meridian. Step up, please. You may proceed. Thank you.
Good afternoon, Your Honors. Jack Watkins from Coffey, Medico, O'Mara, Kapowski for defendants' appellants. This case presents an opportunity for the court to address a distinction that often eludes us litigants, which is that between the sole proximate cause defense to a Labor Law 240 claim and the recalcitrant worker defense. The recalcitrant worker defense
I thought we had addressed this issue on many prior occasions in many other decisions. I thought I had been on the panel a couple of times where we actually addressed that issue.
I'm sure you have, and yet the distinction seems to elude us all the time.
It doesn't elude me, but I didn't think it eluded any of us.
Yeah,
but, yeah.
I don't think we think there is a
Honors.
distinction. One's a subset of the other.
Right, one is a subset of the other,
Right,
precisely the point.
Right, they don't exist separately.
Precisely our point,
Okay,
Your
so
Honor.
what are we missing here that would put you under the sole proximate clause? What are we missing?
Our position here is that there's a question of fact as to whether the plaintiff's negligence was the sole proximate cause.
Counsel, what negligence? Was there a safety device available to him, an adequate safety device?
There was not, Your Honor, and let me address that. We can't pretend otherwise on this record, of course. There was no adequate rigging available for this project to be undertaken. And that was notified to the general contractor, and the general contractor did exactly what a general contractor in that position is supposed to do, instructed that the work halt. It's funny because as I was sitting here watching the other appeals, I actually watched the plaintiff appellant in the Roman v. Zapko case come up here and say that while there were scaffolds available on the other site in that case, and no one sent to bring them to the site that his client was working on. And I thought, that's right, that's exactly what should have happened. Once it was determined that the necessary safety device was not present, the general contractor or site safety manager, whomever it may be, lacking the ability to go back in time and obtain those safety devices, only has one option.
A couple of things sort of distinguish this, and I think you need to discuss it. One of it is that the issue about whether they had the proper device actually didn't come in until the work had already started. By the time this plaintiff got to the premises, they were already, or other workers were already using the same device, the wrong device. The wrong device, which really brings up two issues. One, if other people are using the wrong device and the straps give way and this item falls on him, how could he be the sole proximate cause? And the second thing is that at that time, the work was already in progress, so any direction, assuming that there was a sufficient direction to stop the work, how could it be just on him, given those facts which seem to exist in this record?
Well, Your Honor, I don't think those facts exist on this record in an undisputed manner. If they did, I would agree with you.
Well,
But
is there
is
any
a dispute.
dispute that the work had already begun and that when he came to the site, they were already using the whatever, the device in order to hoist the equipment?
Yes,
The beam?
yes, there was other work being done, but Hudson's site superintendent, Hudson Meridian's Greg McCord, testified that he asked before they started installing the steel beams how they intended to do it.
He wasn't there.
When the plaintiff got there, the forklift was already in the process of hoisting the beams, right?
This is disputed on the record, Your Honor.
But by what? McCord wasn't there. He didn't have any personal knowledge of whether they were actually in the middle of work, so we only have the plaintiff's testimony. By the time I got there, they already had the slabs on the forklift.
But before that had been done, Your Honor, McCord said he spoke to plaintiff and plaintiff being the
plaintiff
foreman
wasn't
of
at
the
the
crew.
site before then. There's no indication, even if we take your client at his word, and his testimony was pretty general. We take him at his word. In terms of the timing of it, there's no indication that he told him at such a point before the workers who were on the premises, who were doing the work, had started the work. There's nothing that disputes that in this record, just nothing.
Your Honor, I'm not saying that you're wrong about that, but I don't see why that would be the relevant question. There was no injury prior to McCord saying, don't do that. Stop the work and wait for the proper safety device.
So how can the plaintiff be the sole proximate cause if he walks onto the site, they're already lifting the beams with the straps break, and then he's injured? How is he the sole proximate cause of that?
Your Honor, he is the foreman of that crew. He's been instructed to not allow that work to continue.
But counsel,
he disregards that instruction.
Counsel, we're beating a dead horse, but at least from our reading of the record, it appears that when the foreman got to the job site, he was a superintendent actually, right? He got to the job site, the hoist was up and the straps broke. So what could he have done to stop the workers from engaging in that activity at that point?
Your Honor, I don't think the record says that it happened the second he arrived. He actively made the decision.
Okay, so if it's already in the air, is he supposed to say, no, stop, don't do that? I mean, at what point in time is he supposed to say something?
Well, Your Honor, that would be a great question for a jury, and I'm
No,
not.
it's a great question for you. That's why I asked it.
Yeah,
Because again, as my colleague says, we're beating a dead horse, so we should probably move on.
I don't know if Your Honors would like me to address Labor Law 200 in this context, but if you would allow me to.
Did Hudson have actual supervisory control over the injury-producing work, sir?
No, absolutely not. And if you look at the respondent's brief, they don't even argue it. So that's my Labor Law 200. If there's nothing further, I'll rest on the record.
Okay, thank you.
May it please the court, Vincent Chirico for the plaintiff respondent.
So did the plaintiff disregard instructions to have his workers wait for the proper device to be brought onto the site?
He did not, Your Honor, and the record is very clear on that. And at the risk of belaboring the issues that the court has already addressed, There are three main problems with both the sole proximate cause and the recalcitrant worker defense here. In the first instance, as to the recalcitrant worker defense, the first question in that inquiry under the law is, was a safety device provided? The answer to that is no. That's where the inquiry should end on that defense, because it doesn't go to question 2, was it available to him and did he choose for no good reason to not use it? So, and on top of that,
Don't you think the stronger argument is that the work was being done when he arrived at the job site?
Absolutely. And there's 2 points on that issue, Your Honor. Number one, there's no conduct. He shows up on the site, the beam is already being lifted, and he is
Well, what should he have done? Should he have said, stop?
He wasn't allowed to because his boss had told him, we're using what we've got. He actually asked his boss for a hoist. He asked his boss for some kind of adequate safety device. His boss first said, I'm going to look for one. The company didn't have one. And when he asked again the week before, his boss said, we're going with what we have. So on the date of the incident, when he shows up at 4 o'clock, because his responsibility was several projects at the same time, the workers were already lifting up the hoist, as the court and Justice Weber indicated. So at that point, there's nothing he can do.
But does that become a question for the jury?
No, because again, there's no conduct that we're talking about. He didn't exercise any conduct. He didn't have an omission. It's already happening. There's nothing he can do.
But couldn't he have stopped the work the day before or 2 days before? Until that device was presented, and therefore they could have done that portion of the work?
No, because at page 245 of the record, his boss says, go ahead, we're using what we've got, use it. He wasn't given an instruction by the general contractor 2 to 3 days before, don't do the work. The general contractor, Mr. McCord, was there earlier that day and said, yeah, this is the wrong equipment. We should put a hole in the roof. We should drop it down and get a crane. Do we have a crane? No, we don't have a crane. So it never gets to the question whether the workers were told
Well,
not
did
to do the
McCord,
work.
though, did the GC say, stop the work, it's unsafe?
Well, that's an issue in the record as well. On one page, on page 251, he says, no, I told them to stop working. On page 452, he says, I did not tell them not to do the work. I only told them that we needed a hoist and a crane and a hole in the roof. So that's an issue of fact.
He says, I didn't tell them they couldn't do the work. I told them they didn't have the right stuff to perform it that evening.
That's correct. And when you combine that, Your Honor, with the fact that he shows up when the act is already taking place, there's no conduct that is called into question as to whether it's a sole proximate cause or whether it's recalcitrant. He shows up and he says in the record, I was just watching. Okay? So, and at best, I think Justice Gish, I think you mentioned it earlier in Appellant's argument.
Well, I'll mention something else. How could he be the sole proximate cause?
That's it.
When it's uncontested that at least his boss told him to go with what he had. So he didn't make the decision all by himself, even assuming that he made a bad decision.
And to continue it from there, Your Honor, at the time he got there, other workers were already doing the work, so it can't be a sole proximate cause. At best, he's working in concert or acting in concert with other workers, which, as we know, is not a sole proximate cause. If the court will allow me 30 seconds to address the 200 argument?
30 seconds.
Okay. So on the 200 argument, the record is clear that Mr. McCord, on behalf of the general contractor, admitted that on prior occasions, he saw the workers doing the same work and knew that it was not the proper work. That constitutes actual notice of the situation going on.
Well, first of all, is this means and methods, or you're arguing defective condition? Isn't this a means and methods case?
If the court, and that we argued that as well in the court below, and the trial court decided not to address that issue.
But
the answer
I'm
to
asking
that,
you, is it
yes.
means, if it's means and methods, isn't the argument you're just making goes really more to general supervisory authority, coordinating, safety, et cetera, as opposed to actual supervisory control over the injury-producing work?
With respect, we disagree, Your Honor. Here, not only was the GC authorized to exercise authority and control, but they actually did exercise authority and control. There's testimony that in the walkthroughs, Mr. McCord was authorized to stop unsafe work, gave direction to masters, and in fact, they performed a job hazard analysis prior to every task. They were in this every single step of the way, and they're the ones who are telling them, hey, we need this, we don't need this. So not only did they have the authority, but they exercised it here. We had wished that the lower court would have addressed that issue. The lower court did not, but we believe that they had the means and methods as well.
Thank you.
Thank you.
All right, rebuttal, counsel?
Thank you, Your Honors. I did check my notes. At pages 220 and to 223 of the record, plaintiff evidently testifies that the beam was actually on the ground at the time that he arrived on the site. That is at least enough to raise an issue of fact as to how far along the work was in progress when the plaintiff arrived at the site. The non-movement on a summary judgment motion, I'm entitled to the benefit of every favorable inference. Any conflict in testimony, including McCord's conflict where he initially says, I told them to stop doing the work, and then a few pages later said, I didn't tell them not to work, I told them that they didn't have what they needed to do at that time. Those are all things
What about the issues regarding him being the sole actor in this? He has to be the sole actor. And is there an issue of fact about his employer telling him to go forward with the work, or that there were other workers as well who were doing the work?
Yes, I think there is an issue of fact there that should go to trial. Absolutely, Your Honor.
Based on what, though?
Well, let me just clarify that a little bit. Just seconds ago, my adversary was up here talking about how the general contractor, McCord, had the authority to stop work. He's also arguing in the same brief and on the same oral argument that hey, look, if the plaintiff's boss told him to go ahead with the work over what McCord told him to do, then he had to do it. So he couldn't be the sole cause. It can't be both, Your Honor. If you have the authority to stop work, and someone can argue that you should be held liable for not exercising that authority, when you do exercise that authority...
Isn't there an easier way to reconcile that maybe what we're talking about is general supervisory authority under the 200 claim?
Well, I would agree with that, Your Honor, but
you want it both ways, too. I mean, your adversary wants it both ways. You want it both ways, too.
No, Your Honor. What I really want here is a consideration of what's equitable and fair, which is, if the correct thing for a general contractor to do, upon realizing for the first time that there is not the appropriate safety device present on site, given that he can't jump into his DeLorean and get it from the past so that it will always already have been present, the best thing he can do when faced with that circumstance, as general contractors throughout this state are on a regular basis, is to stop the work until the proper safety device can be obtained. And if we're going to say that as a matter of law, if a subcontractor ignores that stop work instruction, as a matter of law, that the subcontractor is still not the sole proximate cause of that accident, and the GC is still at fault, then we might as well remove that whole sole proximate cause concept, because there is no way for the GC to exercise his responsibilities on the site in a way that insulates him from liability. None. He has no options. Now, maybe that is the intent of the legislature with Labor Law 240. Maybe.
But again, is there anything clearly stated in the record that the GC told the plaintiff that the work should not proceed without the safety devices?
Yes, it's disputed in the record because a few pages later he says, hold on, I didn't say they couldn't do any work. However,
I'm sorry, counsel, we have a red light. Did McCord say that to plaintiff?
McCord says he did. Plaintiff denies it. Quintessential issue of fact requiring a jury to resolve.
Okay.
If there's nothing further, thank you.
Thank you. Thank you both. No, sir, we're done. We're done. You don't have a cross appeal. Sager versus Ancam. You can proceed.
Good afternoon, Your Honors. May it please the Court, my name is Nancy Mahoney. I'm with the law firm of McElroy, Deutsch, Mulvaney, and Carpenter. I represent the defendant appellant Crosby Valve LLC in this matter. I'd like to focus on 2 points. The first is whether the trial court erred in finding that it could exercise personal jurisdiction over Crosby Valve in this case. And second, if the court agrees with me that was error, why the court should deny the plaintiff's request for jurisdictional discovery. I think we set forth pretty clearly.
Let me just ask this question. In terms of the valves that were given to CEI, because I looked at the documents, the naval records that were supplied, which one of them established that Crosby's valves went to CEI and then went to the Navy that went to the U.S. Hepburn where the plaintiff was stationed?
There is no document that establishes that. The document that the plaintiff submitted establishes nothing more than the fact that Crosby had a contract with a company named Babcock and Wilcox, which was a boiler manufacturer, for the supply of safety valve gags on board a completely different ship, the USS Vreeland. Mr. Seeger never was present on the USS Vreeland. So there is no evidence that, in this case, that Crosby supplied a valve to combustion engineering or through combustion engineering that ended up on the ship where Mr. Seeger was present.
Well, then I guess my follow-up question would be, would the pre-action or the jurisdictional discovery resolve that issue? Because clearly CEI gave some valves to the Navy, and should we extend it that far to say, well, maybe it wound up on the U.S. Hepburn and that's what the discovery would establish?
Discovery, the problem is that just Crosby supplying some valves to the Navy without any connection to the injury and the claim in this case is insufficient to establish personal jurisdiction or to allow jurisdictional discovery. Jurisdictional discovery is not allowed in every single case, Your Honor. There's a threshold showing that needs to be met, and the plaintiffs haven't met it.
But is there evidence of Crosby's exclusive, is there evidence in your client's exclusive control which might require jurisdictional discovery?
I honestly, I don't know, Your Honor, but it doesn't matter, because even if there were evidence that Crosby sold.
Well, it would be Crosby selling to CEI. I mean, obviously, that would be in your control, correct?
I'm sorry, I didn't.
It would be Crosby selling valves to CEI. That information, invoices, et cetera, would be in your control, correct?
Perhaps,
And
depending on.
is that sufficient to get jurisdictional discovery?
No, it is not.
Why?
Because there has to be more than a showing of one transaction or the fact that Crosby sold valves to Combustion Engineering, which was a New York company. There's got to be more of a showing that Crosby purposely injected itself into New York and
It availed itself of the jurisdiction.
Absolutely.
So doing business, in other words, selling to a vendor in New York, and there's no, according to your argument, and there's no articulable nexus to the cause of action here, which did not occur in New York. Clearly, that's conceded, right?
Right.
And there is no, so that even would there be jurisdiction even if the CEI products found their way into ships outside of New York to which the plaintiff was exposed?
No. Your Honor, there still has to be, one contract is not sufficient. If there's no evidence that there were any negotiations, there were any phone calls into New York between, by Crosby to Combustion Engineering. There has to be more of a showing of purposeful availment and a transaction. There was no transaction here. There's been no evidence of a transaction entered into by Crosby with Combustion Engineering that would justify personal jurisdiction or that would justify jurisdictional discovery. You can't base jurisdictional discovery on mere speculation that there might be a sale to a New York company that had nothing to, the objective of that sale was to supply valves to a ship that was constructed in California. The objective of that contract, if it existed, had no connection to the state of New York.
But do we not know that Crosby did in fact sell valves to CEI?
For a different ship, yeah. That's not at issue here.
So if we have that, we know that there was a contract between Crosby and CEI for valves. So then would not discovery then determine the substance of those contracts, whether those valves then made their way onto this particular ship, et cetera?
There is no evidence that there was any kind of ongoing relationship between Crosby and Combustion Engineering. In this case, plaintiffs haven't presented that. They've presented one document that shows that before the plaintiff was even exposed in this case, that a Crosby valve was on a different ship in a different location.
See, that was my question, because you made reference to there's nothing in the record concerning any telephone calls. I don't know whether we had email back when this occurred, but you made reference that there were no telephone calls or correspondence or anything of that nature. Would that not be discoverable? Would that not be in your possession in terms of whether there were any such documents and information?
Potentially, yes. But again, the relatedness aspect has to be demonstrated even at this stage where the plaintiff has to show. All of the cases from this court that were cited in our brief and in plaintiff's brief say that there has to be more than sheer speculation. You've got to show something, a phone call, a letter, and even if you show those things, every single case that we cited to Your Honor and that they cited to Your Honors say that isn't good enough. There's got to be a much more substantial availment, a direction, an activity in the forum, and a substantial relationship to the actual claim at issue, which is exposure to asbestos in California, a failure to warn in California.
Okay, thank you. Let's hear from your adversary.
Thank you, Your Honor.
Good afternoon, Jason Weinstein for the respondent, the Seeger family.
Counsel, I'm sorry. Going back to the issue of jurisdictional discovery, I think you can make an argument with respect to what may be in the exclusive possession of Crosby in terms of whether or not there was purposeful activity selling valves to CEI in New York. But what evidence supports your contention that CEI then sold the Navy its boilers, which ended up on a ship that the plaintiff was on?
CEI being Crosby? I'm not sure I understand.
No, CEI is it's combustible engineering.
Okay. The fact that we presented documentary evidence that there were combustion engineering boilers on the ship where Mr. Seeger served and where he specifically testified, which my adversary absolutely failed to mention, Mr. Seeger testified that he was in the boiler room and he put Crosby valves in the boiler room specifically. So that is the evidence that he was exposed to asbestos from Crosby valves.
But
We
that
have
doesn't, yeah, but that doesn't bring you through New York. You need the articulable nexus of the purposeful activity in New York to the cause of action. And so let me ask you that. Where does that come in?
Okay. Specifically, what we have is the corporate representative from Crosby Valves, Robert Martin, in deposition testimony multiple times, specifically testified that it was standard practice of Crosby not to sell its valves directly to the Navy, but to sell its valves to the boiler manufacturer. And in fact, on page 452 of the record, Mr. Martin specifically named Combustion Engineering as one of the boiler manufacturers to which Crosby sold its valves.
But then the issue becomes, how did these valves make it onto the ship where the plaintiff was stationed, right? We have proof that was on a different ship, and that might be the nexus there for that, if he had been on that ship. But what about this?
Well, let me be clear. The purpose of presenting that evidence was simply to show the pattern of behavior of Crosby, to show that it was standard practice, along with the deposition testimony of Mr. Martin, that it was the standard practice of Crosby to sell to the boiler manufacturers. And the other ship was only mentioned because that we do have an actual record of the sale. That is the one piece of direct evidence, I'll admit, is lacking here. But circumstantially, it's an extremely strong circumstantial case. We have the pattern of activity admitted by Crosby. We have the testimony by Mr. Seeger that Crosby valves were in the boiler room. And we have the documentary evidence that the Combustion Engineering
And you think that
boilers
that's
were on the
enough for
ship.
them, under due process standards, for them to believe because they've sold the valves to CEI, that they would be hauled into a New York court for a California tort?
Well,
I think
CPLR
that is...
3021 specifically states that if a company transacts business within the state, in other words, to a New York company.
We all know what it says. We've read it, but it's still subject to a two-prong analysis along the lines that I've discussed, so that it and that it otherwise comports with due process. And last I looked at the Supreme Court of the United States, including cases like Bristol-Myers Squibb, they talked about the fact that just having a vendor in New York is not really sufficient to get long-armed or specific jurisdiction over an out-of-state corporation.
I don't believe that's the situation with any of those cases, Your Honor. I would dispute that.
Actually, I really do believe that it says that, but I'll look at them again. But it does talk about an articulable nexus to the cause of action, and here being the site of the exposure was not New York. The manufacturer of the valves that contained asbestos was not in New York. Your only basis for jurisdiction of being hailed into a New York case is that somehow along the chain of events, these valves might have been in New York at one time or another.
Not that the valves were in New York, but that Crosby was specifically availing itself of the New York market by selling its products to a New York corporation, and these were the products that caused Mr. Seeger's injury. That is an absolute direct connection to the cause of action here, and in fact, it's much closer to the cause of action in terms of the connection than in the Leachy case, where the foreign defendant simply used a correspondent account in New York, and there was no evidence even that that correspondent account was used to purchase any of the weapons or the munitions which caused the terrorist acts involved in the injury to the plaintiff in that case. Here, specifically, Crosby sold to a New York company the exact products which caused Mr. Seeger's injury. And to the extent that this court may have any lingering doubts regarding the circumstances of the sale, you know, how much of that physically took place in New York, which again isn't even required, that would be exactly the kind of issue that jurisdictional discovery could resolve, either through questioning of witnesses from Crosby Valves or even trying to obtain additional information from combustion engineering regarding the sale. Thank you.
Thank you. Rebuttal?
Yes, Your Honors, just a few points. There's no evidence in this case that that Mr. Seeger saw Crosby valves associated with a combustion engineering boiler on board the USS Hepburn. He was specifically
asked. There was testimony that he testified to the same.
He was specifically asked, and this is cited in our reply brief, it's quoted in our reply brief, what piece of equipment did you see the Crosby valves associated with? Or did you see them, what was the piece of equipment you saw the valves associated with? I don't know. He was specifically asked. He didn't know what piece of equipment.
But he saw the name Crosby. That was his testimony.
He claims he saw a Crosby valve. As counsel said, in the boiler room, there's lots of other pieces of equipment in the boiler room that a Crosby valve could have been associated with. So the connection to combustion engineering has not been made. Also, I'd like to address counsel's statements about a pattern and about standard practice of Crosby to supply valves to manufacturers. While Mr. Martin did testify to that effect, there is no testimony that it was the standard practice. There's evidence that Crosby did, at times, sell directly to the manufacturer. There's also evidence that they sold to other, and discovery would show this, that they sold to the Navy in certain instances. So that's not an adequate basis. Finally, Judge Gish, you're right. In Bristol-Myers Squibb, one of the second holding of the court was the fact that Bristol-Myers Squibb entered into an exclusive distributorship agreement with McKesson, which was a California company, to distribute its products in California, was not a sufficient basis to impose personal jurisdiction.
Okay, thank you.
Thank you, Your Honors.
Gemini Insurance versus Golden Insurance.
Good afternoon. May it please the court. Joel Simon on behalf of the appellant Golden Insurance from Smith Major. Your Honors, the questions presented here is if a policy of insurance does not utilize the words executed or signed, when, if ever, must a contract be signed so as to comply with the additional insured provision? Every First Department case referenced by the lower court and in the briefs that found coverage was either a purchase order with no signature line or had a signature line and was signed and did not require privity of contract.
Circling back to the policy, to the Golden policy, does that policy require that management be a signator to the trade contract?
It says, yes, Your Honor, it says that every additional insured, and I can reference the actual language, it requires what's called privity of contract. It states that the entities seeking the additional insured coverage must have, you and such person or organization have agreed in writing in a contract or agreement. That's been interpreted to require privity. How do you have privity of contract without a signature? Your Honors, if I write up an agreement saying you're going to repair my roof, is there privity between us? Have you agreed to that? No, not until you have signed onto that contract. The requirement of privity requires the signature of the contract. Without that, there's no privity.
Well, counsel, let me just ask you this question because you mentioned the purchase order, which was the subject of the Zurich case. How is this contract unlike that purchase order?
The purchase order, first off, the additional insured provision in the Zurich case did not require privity. Secondly, the contract, the purchase order, excuse me, did not have a signature line. There was no place to sign. So when they...
And then just following with that, like in the Netherlands case, where it was a bid proposal, there was a signature line in that case, and that kind of went along the lines of the Zurich reasoning as opposed to the reasoning of Gilbane, which requires something else, right?
Exact. Netherlands did not require privity either. These are cases in which the policy of insurance does not require privity. My point, Your Honor, is that when the policy, which is what controls the additional insured endowment, when the policy requires privity, it's the same as saying, sign the contract. How can you have privity without signing the contract? As Gilbane noted, as National Abatement noted, as Cusimano noted, and Cusimano is a good example, there were signature lines on the court said that it's clear that the signature lines require a signature. Without that, we don't have a contract under the policy. It's required by the contract when you have signature lines, and it's required by the policy where it requires privity. And that's my key point, Your Honors, is where privity is required. If we didn't have that requirement, maybe we'd be having a different discussion. But where privity is required, you can't have privity without signing on to the contract. As I stated, Your Honors, you're not required to repair my roof simply because I write up an agreement. You have to sign on to that contract. Until you do, there's no privity between us. Thank you.
Thank you.
Good afternoon, Your Honors. I think, simply stated, I think words matter.
Well, counsel, let me just ask you this question. How do we distinguish the Gilbane case from these facts where contractual privity was required? How do we distinguish that case?
Well, there's no question that the party, New York Management, was a participant or a party to the agreement. In Gilbane, the issue was whether there was privity. Here, the issue isn't whether there's privity, but whether the agreement needs to be signed. And I think that the point that I want to make to the court is in the reply brief that was filed by Golden's counsel, they refer to the Cusimano decision as by this court as supporting their position in this matter. The fact is, the First Department affirmance in Cusimano did not cite to the additional insured endorsement that was at issue in that matter. The trial court decision, however, did. And the trial court's decision reference to the additional insured endorsement says, the following are also an insured when you have agreed in writing in a contract or agreement that another person or organization be added as an additional insured on your policy, comma, provided the injury or damage occurs subsequent to the execution of the contract or agreement. That's the reason why we called this court's attention to the Cusimano decision as making clear that if you want to have execution as a prerequisite to additional insured coverage, you can put that into your endorsement. This endorsement does not state that. Judge Maisley correctly determined that all that it required was a contract or agreement in which New York Management was a participant. They were in privity of contract. This was an agreement that was entered into among the owner, the construction manager, and the trade contractor.
There is no dispute that that contract, that it was a contract, the trade contract was a valid contract.
That's correct. And that work was being performed pursuant to that contract. The argument that is being made, Golden's acknowledged that the owner is an additional insured because they've got the owner's signature.
Yeah, they signed it.
Right. There's a question of fact as to whether New York Management did sign it. When we first got this matter, the contract that we produced during discovery did not have or wasn't signed by New York Management. We had to go through defense counsel in the underlying case to try to get a contract.
But that dispute, and the reason why I don't want to take too much time on that dispute, because all that gets the parties is that you don't get a disposition like the lower court gave you, which was a summary adjudication on the issue. So the question really is here, in looking at the language of the policy and looking at the trade contract to see whether it otherwise satisfies the language of the insurance policy regarding who can be an additional insured. Right?
And
That's
I
it.
submit to this court that it does, because it says when you and such person or organization have agreed in writing in a contract or agreement. These parties were participants to that contract or agreement in which they agreed, in which Golden's named insured agreed to provide additional insured coverage to both the owner and the construction manager. The other point I want to make, and this is tied to the argument that privity necessarily requires execution of the contract, is the simple fact that there have been a number of court decisions, even though the Cusimano endorsement wasn't literally the same as the form endorsement in the Golden policy. If you look at the case Chelsea Piers versus Colony Insurance Company, that was the exact same endorsement, form endorsement that's found in the Golden policy, and the court in that case determined that it didn't need to be executed. It just required a written contract or agreement in which these people or entities were participants. Similarly, the Fourth Department's decision in the LM3 case, another decision in which the court held that the agreement didn't need to be signed in order for privity to exist. It's very significant that in setting forth the proposition that privity necessarily requires execution, that counsel has not cited to any decision that specifically makes that determination. There is no authority for that specific proposition. The privity is just simply, if the construction manager had entered into a separate agreement with the owner, and the owner then entered into an agreement with Mr. Simon's client that said both the owner and the construction manager should be provided with additional insured coverage, and we went to Golden, Golden would say, well, no, the construction manager wasn't a participant or in privity of contract, so we deny coverage, we would agree. But here, New York Management unquestionably was a participant in that agreement, pursuant to which work was being performed at the time of the accident, which was through an employee of New York, Golden's named insured.
Okay, thank you.
Thank you, Your Honors.
Your rebuttal?
Just like to bring up several quick points, Your Honor. First, we have the question of when was the contract even signed? The burden is on the parties seeking the coverage to prove there is coverage. They provided an affidavit after almost 2 years of not giving us a contract that was signed. They finally come up with one that was signed, and then they say, well, it may have been signed before the date of the accident, it may have been signed after the date of the accident. We're not really sure. That's their burden. They did not meet that burden.
But as I said to your adversary, the issue that we have been at least focusing on in oral argument is a matter of law based upon a reading of the policy. So that factual dispute wouldn't have any bearing on this.
But they didn't meet their burden, Your Honor. When was it signed? We don't know. Secondly, you raised the point to my adversary regarding that there was a contract in effect between the parties. The work was being done, yes, but as I think it was noted, I seem to have misplaced some of my papers, but as it seemed to have been noticed in Gilbane, you can have the issue of whether there's a contract between the parties is not the same issue as to whether it constitutes a contract as required by the insurance policy.
The compliance with the insurance policy.
Exactly. The Cusimano case required privity. The court found that there was no coverage because it was not signed. They said there's no ambiguity here. This needed to be signed. And in our situation here, Your Honors, the contract wasn't signed. There's a difference between having an agreement, simply writing somebody's name in, and privity of contract. All the cases that require privity of contract found that there was no coverage if it wasn't signed. Thank you, Your Honors.
Okay, thank you. Thank you both. Okay, our final case for argument today is People versus DeLeon. You can proceed. Oh, wait a minute.
Good afternoon, Your Honors. My name is Robin Richardson. I'm with the Legal Aid Society on behalf of Mr. De Leon, appellant. Defendants in SOAR proceedings have rights to appeal. That right is gutted when the lower court fails to make a record of its determinations and the findings of fact and conclusions of law on which those determinations are based.
Are we allowed to do it up here if the record permits?
Your Honor, if there is enough of a record for meaningful review, but here the court was absolutely silent as to Mr. De Leon's downward departure argument. The purpose of the law is so that the defendant and the appellate court have notice as to the reasoning behind
Didn't the order indicate that one of the reasons that the downward departure was denied or was he had already had a prior sex offender registration requirement, which would make him now a presumptive level 3?
It would make him a presumptive level 3, that the court can find on the record that he was a presumptive level 3. However, the court must also consider his downward departure argument. The lower court must consider it.
So let's talk about the mitigating factors here. The mitigating factors cited by the defendant, were they taken or not taken into account by the RAI?
They were not taken completely into account by the RAI. For instance, this defendant had voluminous proof of the fact that he had taken responsibility for his actions. Now, under the RAI and the guidelines, a defendant can deny their actions all the way up through, all the way up until their most recent statement. And taking a responsibility could happen after they've been threatened to be kicked out of treatment, and they would still receive 0 points under the RAI. The exact same points that my client received when he confessed his actions to the complainant's mother, knowing that that would result in his arrest. When he cooperated fully with the police and in his statement asked for help. He was forthcoming at every opportunity, and then he devoted himself to rehabilitation while he was incarcerated. He had high scores, top scores in sex offender treatment, and the guidelines have also stated that having exceptional response to treatment is a valid reason for a downward departure. Now, respondent's brief briefly states that he had already taken sex offender treatment at the time of his offense. There's no indication that that's true at all. That's not in the record. His first offense happened in 1994, years before the passage of sex offender laws anywhere in the country. And there's just no record that he had actually had any sort of treatment. And if he had, the treatment that he had was 20 years older than the treatment that he received now. We have no idea what kind of response he had to that treatment. So he has that, which goes above and beyond the RAI. He also has, significant support from his family, his extended family, from his church, and from rehabilitative programs. That goes far above and beyond what's considered in the RAI, where a complainant could be released with no support at all and still receive a 0 for not having an inappropriate living situation. This is not considered by the RAI.
So when the court stated that it had reviewed the documents provided and still found that the people had met their burdens, but when the court stated that it had reviewed the documents provided, was that not an indication that it had in fact reviewed all of the documents, including the voluminous letters, the fact that the defendant took responsibility for his actions, the fact that he wrote a letter expressing remorse, et cetera?
Well, based on this record, we can infer that the court reviewed those, but we have no indication as to what his reasoning was for denying the downward departure. Gelati sets forth...
Well, I mean, to say I've reviewed it and I find that the people have met their burden and therefore I'm not going to grant the downward departure, why would that not mean that the court had in fact considered all of the documents and decided not to grant the downward departure?
Well,
and he's presumptive.
Whether the people meet their burden is a different question than the downward departure.
Okay, so the court said I've reviewed the documents and the application for a downward departure is denied.
Well, we don't have any insight into his reasoning, and that's an important part of meaningful review. I mean, for instance, the court could have seen what he had done in sex offender treatment and said, you know what, actually, I don't think that that's mitigation at all. And I think this court would think that that was wrong. We don't have insight into that reasoning.
But the mitigation would be out in this instance, outweighed by the presumptive level 3 based upon his prior SORA, right? That's what the order ultimately said.
That's not what the order says. It just says he's a presumptive level 3. We found that the people have met their burden, and he doesn't address the downward departure argument at all. In Gelati, the downward departure argument, that consideration happens after the REI discussion and whether or not the people meet their burden.
But it's on the same evidence.
It's not on the same evidence.
Factually, the record doesn't have to be further developed. Your objection is that he didn't go through the three-tier analysis in Gelati, so we don't know how he reached the conclusion, no downward departure. But the record is the same nonetheless.
The record. Yeah, this court could absolutely conduct your own SORA hearing. You could look at this record and you could
Well, we would conduct a hearing. We could make a determination on the record, is what I'm asking.
But what you would not be able to do is make a determination about whether or not the lower court was correct in their reasoning for the denial.
Sure we could. It would, I mean, it's a de novo look.
Excuse me?
Sure we could. We can make a decision de novo. We have that authority in almost every appeal anyway. Okay. All right, let's hear from your adversary.
Good afternoon. May it please the court. Diana Lewis for the Office of the District Attorney of the Bronx, with the respondent in this case. Unless the court has any questions for me, I will just ask for an affirmance and yield my time.
You waited all this time and you're going to yield your time?
Yeah.
She only asked for 2 minutes anyway.
Say something if you'd like, but.
It's okay. It's a long day for all of us, but I think your adversary has some rebuttal anyway, right? No? All right, ladies, thank you for waiting.
Thank you.
Right.
Alice, that is all. That's it. See you later. See you downstairs, Dave.